Hello and welcome to another episode of from EQUES Law Group on our oil and gas practice, trying to empower folks in the general public with information about a very, very detailed area of the law and economics, and that is oil and gas development in Southeastern Ohio. And leading off this episode is my partner, Kate Kimball.
Thanks, Tom. So in our last episode, we talked about parfaits, basically. And so we're going to pick up and talk about that here too. So far in the entire series, we've talked about kind of oil and gas law in general and what it looks like in Ohio, why we do this, in general kind of property law issues and questions. And so one of those is that at the simplest ownership, somebody might own from the surface to the core of the earth, right? And within that, and if anybody really is has dug much in their yard even, like you might know that there are layers in there, right, that are different things. And so that's like the layers of a parfait when we've talked about this. And somebody might own all of the layers, and sometimes that may not be true. And so that's kind of what we're going to talk about in this episode is what does that mean? What's it look like? And what kinds of issues do we run into that kind of go along with that. So in our last episode, we talked about a bundle of sticks, and I tried to convince you that maybe it should be a bundle of spoons to go with the parfait analogy, but I don't know that you liked that.
Well, I especially I've warmed to the idea now that my brain has had a chance to adjust to it. I think if you say that a spoon gives you the right to dig out the particular layer, then that's very indicative of coal and hydrocarbons and oil and gas and as I'm not sure if we're going to deal with it in this episode or not, even rare earth minerals that we're running into now that might be under somebody's land. Yeah, if you say that a spoon is a bundle of rights that gives you the right to withdraw your layer of the parfait from underneath the surface, I think that's a good analogy.
Well, thanks. I appreciate it.
You need to copyright it.
It was it was kind of like an epiphany. Like I think if we're going with parfait, that just makes sense. And that's really the idea that the parfait is the physical property, right? Like if you're standing in your front yard and you have 100 acres, you might own every layer there, and you probably don't have, but we'll say you might have a fee simple there, right? Like you own all of the rights to the surface and every layer there. To go along with that, you would have this bundle of spoons that you could dole out to people as you sold rights to them. Probably now, if you have that 100-acre farm, there's probably already somebody who has spoons that belong to your property, right? Like some right to do something there, like maybe run a power line. So there's an easement.
Maybe a shared driveway on the surface.
Sure.
With your neighbor. Yeah.
Right. Maybe you rent out a house on it. So a tenant has some kind of spoon for your parfait, right? And those people, you would literally give it to them and they would hold that. And those rights can be infinite. Portions of interests, only rights to do certain things, like a driveway might be just the right to cross the property, right? They don't own the driveway, they own the right to pass over your property to do that, right?
Right. And then just looking at the analogy a little bit, my brain is coming up with the closer to the surface, the shorter the spoon. Okay. For instance, it doesn't take a lot of resources from the surface to drill a water well.
Sure.
But if we're talking about a deep fractionated well that is a horizontal well, that is an awfully long teaspoon because of the resources that it takes to do that. So I'm thinking it's actually a drawer full of spoons of potentially different sizes, and I don't know if that works with your analogy or not.
I can see that.
Yeah.
So how deep is a water well? Like 50 feet?
No, probably depending upon the area.
Sure.
Couple 100 feet maybe.
Okay.
Yeah.
And a shallow oil and gas well that we talk about sometimes, which are not really shallow, how deep are they usually? Do you know?
They may be 3,000 to 5,000 feet.
Right, like into sandstone. So in the parfait, there's water, types of sandstone, types of limestone, and then we get down to shale, right?
Right.
And the horizontal wells, depending on where you are, they can be like 8 to 9 or 10,000 feet deep, right?
Right. Right.
So that would be a pretty long spoon, I guess, to get all the way down there.
Very long teaspoon there.
Right. So what kinds of rights could be conveyed with a spoon, though? Like, they're not always unlimited, are they? It's not as if, kind of like when we talk about the driveway, if your neighbor has that right, they don't have an unlimited right to your property, right?
No, it's not like if they've got the right over that the driveway goes along the eastern edge of your property, you don't expect them having a bulldozer on the western edge of your property. It needs to be limited. Right. But the problem is, I think, Kate, that when we look at these rights that are created, as we said in the last episode, by somebody holding some right back. I give you this surface, but I'm going to hold back the rights to the minerals, or as is also the situation, if I lease my mineral rights, okay, is to make sure that there's some kind of understanding over the extent of those rights as they affect the other rights. And we've seen plenty of old leases that are done on one page, very small print. We've seen a lot of reservations and exceptions that are just, they don't give us any guidance. And the law in Ohio will develop, if there's an economic interest, to push a case up the ladder to where, like, the Ohio Supreme Court will give us a decision on what Ohio law is. But the problem is, before the horizontal well gas boom starting in 2010, 2011, most of these oil and gas booms before, with what we call the shallow wells, would last maybe 3 to 6 years. Well, that doesn't give you enough time to work through the trial court, the Court of Appeals, and then the Supreme Court, which, as we know from our cases, takes 4 to 5 years. So the economic, the boom would bust, the economic incentive would dry up, and we never really developed Ohio law until about the past 15 years or so.
Sure. So you mentioned reservations,
right,
when you were just talking about that. So what, and we talked about this in the last episode some, what that means and what a reservation might look like. What kinds of issues have we seen, or that you know of, over time have there been with reservations? Well,
one that we often dealt with was, who was the reservation or exception? And basically that's the language in the deed that I'm giving you this, but I'm not giving you that.
Right.
Is what it says. Who was it for? Okay. We, up until 1925, Ohio law generally required that if you were going to keep that for yourself and future generations, your heirs, you had to have what were called words of heirship. Okay.
Just like magic words.
Magic words. Me, on behalf of myself, my heirs, my successors, that's people I sell it to, and my assigns, the people that I might assign it to. Like, we haven't really covered how mortgages and other kinds of financing options can affect land ownership. You can get, you can pledge or you can mortgage not only surface rights, but you can also do that with mineral rights. The problem is, and I pointed out, prior to 1925, does it have words of inheritance? Well, we've kind of sorted through that, and the Supreme Court kind of says, that really doesn't matter. That was an issue for 5 or 6 years. But the main problem is the reservation and exception language in the deeds were not standard.
No, not at all. I've rarely seen two that look alike.
Not even within the same law office.
Sure.
We've seen different wording from different lawyers, and we happen to read the work of the different lawyers because they were from small towns like Cadiz or St. Clairsville or Woodsfield or Steubenville who would do this, and it's kind of like every time they sat down for a deed, I suspect they just said, oh, well, this is the way I'm going to phrase it this time. But our Supreme Court has said the wording of those deeds, the wording of those old leases are very important, and therefore it's difficult sometimes to apply general rules of law when you have to look at the language of the individual deed or lease or instrument, whatever you're looking at. I know you've run into that.
Yes. I mean, we've had whole cases over particular language in a mineral reservation. And what does that mean? And I think part of the reason that this can get complicated so fast is that the language, first, the language is not standard, and different rights can be kept in the minerals. Sometimes it says all minerals. Sometimes people only kept the royalty interest.
What's the difference between owning the minerals and having the royalty interest in the minerals?
That is a great question. And so I would say owning the minerals, royalty interest, leasing them, those are all separate, right? So I would summarize that as being mineral ownership is you own all minerals, period. So it's like a sub fee simple, right? Like in just the minerals. I don't know what that means for like pore space, like empty space underground. Some states have decided who owns that. I don't know that Ohio has.
Okay. Why is pore space important in 2024?
Sure.
And by the way, it wasn't when we first got into this in 2010, 2011, nobody was concerned about pore space. Why is that important now?
So, and it's new. So my understanding is carbon sequestration, like basically storing carbon underground, would be an empty space. So there's empty space underground where things have been removed or just because there's empty space there anyway, right? Mm-hmm. So being used for storage basically would be the purpose of it. So then there are questions on who owns that right.
Sure. And what kinds of things are they wanting to store? And then, by the way, this is not just a lot of our listeners might be aware of what are called brine injection wells, which are uber deep. I mean, you got to watch out. You don't lubricate a fault, or you can get like up in Northeastern Ohio, you can get earthquake activity. We're not talking about disposal of brine and other things. We're talking about storing something because it has value, right? What kinds of things do they want to store? So
the most recent experience I've had with someone for this was to store carbon. And like that's new. Mm-hmm. And you're talking about like half-lives of carbon and how much you can store and basically trying to figure out where pore space even is, who has the right to it. Is there something else you're thinking of for storage too?
I'm just thinking that there's literature, and some of our clients have contacted us, and we're looking at rare earth metals like lithium, which goes to make batteries, that somehow in what they extract in the oil and gas production also has some rare earth metals in it. And people are looking to be able to store that, right? And sometimes that's related to brine. Right. So pulling it out, and I mean, that's all so new that like we're trying to figure out what it even would mean. But that's even a separate right. So how do you lease pore space? That's not even leasing the right to minerals. Right. So ownership is one thing. The right to lease them, which would be giving somebody your spoon to come produce something or use the property for something, right? So when we're talking about like the horizontal wells, that lease would usually be to an operator or sometimes a non-operator saying you have the right to come produce oil and gas here. Usually, hopefully it's limited in time. They have certain requirements required of them. We don't really see like the one-page lease anymore, which is helpful for landowners to have more protections on the property. So that's kind of what a lease might be. A mineral sale would be selling your spoon. So that's selling your ownership or a portion of it, or even a portion of just your royalty interest, or it can take all kinds of forms and be splintered in so many directions, which if you're an optimist, maybe that means you have a lot of options, right? To try to figure out how to use your property to best suit you and your needs. And you have a lot of options to protect it that way too. Right. But the devil is always in the details, isn't it? Right. I remember we have done a lot of educational programs, going out speaking at high schools, granges, community halls, et cetera. And I remember coming out of one, I think it was in Marietta, and hearing this really bad argument between this older guy and this younger guy. The older guy was saying, we need to sell the mineral rights under our farm. We might not get as much over time as if we just leased it, but if we sell it, we get cash on the barrelhead, and it's sure. And the younger man was saying, no, the potential for leasing and making royalties is far more than what we're going to get. It was actually getting half violent until I went over and there was a lady who was listening to it, and I said, do you know these gentlemen? And she says, yes, that's my husband and my son. Sometimes your economic decisions are driven by where you are in life.
Sure.
The father wanted to cash out now. He wanted to buy his F-150, and he wanted to buy his John Deere, and then he wanted a place in Florida, and he wanted the money to do that now. The son, however, had a longer range view and was willing to wait for his money and run the risk of their property being produced. Mm-hmm. So there's also something that we as oil and gas lawyers representing landowners, we have to be attuned to what does the client want here.
Right.
What do they see as their best interests?
Exactly. I mean, I've had that exact discussion with people, right? Because it's your property, so you can do whatever you want with it. But I think that it usually is the distinction is getting paid something now and being as certain as possible of that, or waiting and over the long term being paid more for royalty. And so many of things, that's like the devil's still in the details, right? Like, what does that mean? What are you actually selling? Are you keeping anything? What does a royalty rate look like in a lease? If there even will be production. So all of those things go into it. But I think that's usually how people weigh it, is the way you described it.
So negotiating those kinds of issues, whether it's a sale or a lease of mineral rights, we do that.
We do.
We represent folks. So there is the whole negotiation part of that. But there's also times when we run into conflict that we just can't work out. Between a landowner and a producer, between landowners and other landowners, between heirs of this reservation and that reservation, which, by the way, we talked about a reservation exception. It's not uncommon, is it, to see what we call a chain of title or a chain of deeds, successive owners with different reservations and exceptions, or sometimes the same language repeated deed after deed. What kind of problems does that cause?
All kinds of problems, right? So that's usually the first thing that we would do. If somebody says, like, I'm being questioned about my ownership, or I just want to know who owns the minerals for sure, people usually say, well, I want to know for sure under my property, which is a hard thing for us to say that something is certain, right? Like, I can't do that. The first thing that we usually do, though, maybe almost always, is tell them that they need title work done to make sure that there aren't reservations in there from 1897 or 1920 or whenever that would affect their interests now. And like you said, sometimes there will be multiples of them. Sometimes they won't use the same wording. Sometimes they will just be a repetition of an old one. Like, I'm going to do a new deed today and just copy the last one, which also creates problems. All of those things go into who owns it now and can affect, who's sitting there today. Sometimes a service owner will think they own it, and we just want to make sure that we know what reservations looked like, if there were any.
Well, if I'm the surface owner, the guy who sold it to me said he owned the mineral rights. Isn't that good enough?
He probably did say that, right? And it's probably not good enough, And people have told me that before, and people will be certain they own them because their families had the property for 50 years. And we'll get into these things in later episodes, but there's really two ways in Ohio law that mineral ownership is affected by those past reservations or actions of a prior owner. So when whoever owned it before sold all of their sticks or spoons, but they kept their reservation, that's still lingering out there somewhere. It needs dealt with. Right. So even if the prior owner said he owned it, that's still a title work question.
So Kate, you mentioned getting a title search. Okay. Mm-hmm. So let's say I'm the client and I say, well, I just bought a home and I paid for as part of that in order to get a mortgage, a 40-year title search. And that cost about $400. So is that what you're talking about?
It is not. Unfortunately, it's not. So, and we have a title company. And so we do marketable title searches like that, 40-year searches for residential property all the time. They do not search minerals like we're talking about. It should show in those deeds in those 40 years if reservations appear. But we really need to care about reservations pretty much ever on the property because of the statutes that we'll talk about in later episodes with the Marketable Title Act and the Dormant Mineral Act, where those windows fall. So usually that's not good enough. The mineral title work is much more involved, which unfortunately also means it's usually much more expensive than just the 42-year search when you bought your house.
And we kind of dealt with this in the last episode, but not only are you checking the chain of ownership for the property, if there is a reservation, you have to do a lot of genealogical research in order to figure out who are the current heirs of that interest that may be 100 years old.
Right. And did they ever sell that reservation to somebody else or transfer it through probate court or not, or things like that. So you're tracing those reservations and the heirs of them, which can get really involved.
So, and before we wrap up this episode, you mentioned something about windows. Is that a window of time that we need to look at in order to determine if that old interest is still valid?
Yes. So there's really two of them, and they're separate. So the Ohio Supreme Court said they both apply, but they don't both operate the same. So one of them is in the Dormant Mineral Act. And people talk about this a lot because they hear this, and if they've owned their property for more than 20 years, which is the window in that statute, people will be sure that they can or can't do something with the Dormant Mineral Act. So that's really a 20-year window of like non-use of minerals. And it's more complicated than that. There are exceptions to it and things that we'll talk about later, but that's one of the windows. In the other one, it's the Marketable Title Act, and there's this 40-year window of having clear title. And there's a lot of case law about the Marketable Title Act, how you find where the 40-year window starts. It's not 40 years from today back, so that's why we have to search so far back. Because the window, I've heard someone call it the floating 40-year window, which is not really useful all the time. At least it's not simple all the time.
It's not simple. It's not simple. And we'll get into some more of that in the future, which, by the way, I think, folks, that our purpose in doing these episodes is not to make you folks into real estate or oil and gas experts, but just to kind of demonstrate for you that there is real economic benefit if you're considering having mineral interest drawn, hydrocarbons, whatever it's going to be in the future.
Rare earth minerals.
Right, drawn from under your land. And this is something that's sometimes beyond the ability of your general practitioner or a family lawyer. And the number of lawyers that we run into are relatively small. Most of them work for the big oil and gas companies. There are several like us that are landowner advocates. We're just trying to tell you that this is kind of not going and get us, to use a medical term, not going in and getting a splinter taken out of your finger. This is heart surgery that we're talking about, heart surgery for your land. And we'd be happy to help you if you have any questions.
Thank you.
Thank you.